Hello. So we are going to be doing closing arguments in Florida versus Lawrence Dority. If you have not followed this trial, you can catch up pretty quickly. Everything from opening statements through to jury charges, figuring out what instructions we're going to give the jury, took place yesterday. You can watch that all condensed down in a 4-hour stream. It's linked in the description. And we're going to get closings. Openings were pretty short. And personally, I woke up this morning, started thinking about this case before kicking the stream off. And I'm just like, man, I have so many questions. So, this is a self defense case. It's really more stand your ground than castle doctrine because it took place at the defendant's like living complex, and the car that the victim was driving was on the road near his house, but like, you have your lawn ends and then the road starts and he's on the other side of that little living complex road. So more stand your ground than castle doctrine, although it seems like the attorney was getting that confused or trying to be very expansive in what stand your ground would cover. Um, there are some things that are a bit reminiscent of the Travis Rudolph trial, although I think they're ultimately totally different facts, totally different things. Remember with Travis Rudolph, people come to his house to jump him at the request of a girl he was dealing with, who said to these family members of hers, he was hitting on me, like physically hitting me. Meanwhile, there seems to be ring footage of her hitting Travis Rudolph, so who knows? But these guys take her at her word, family members and their friends. They show up in a car full of people trying to talk to Travis Rudolph at his house where he lives with his mother and his brother. And brother's not having it. They end up fighting. They say fighting words or whatever, but brother ends up running down the road after the others when they start to pull away. Travis, to protect his brother, says he ran out to protect his baby brother, and guy in the passenger seat pulls up a gun. He can see it through the window and is about to shoot at his brother. So Travis Rudolph shoots the guy. Guy dies. Now, one would think, okay, we shouldn't be chasing people down. We could be safe. But in that scenario, Travis Rudolph wasn't the one precipitating the situation. In his mind, this is why self-defense, justifiable use of force can be so interesting because it can change in an instant. Self-defense can be, or defense of others, can be something that might be lawful for more than one person at a given instant. And in this scenario, if Travis Rudolph is trying to protect his brother and sees somebody else pull a firearm, even though maybe the brother shouldn't have been running after the car, now that circumstances change because a firearm has been pulled up at somebody else. So I loved the Travis Rudolph case. This one has a quite different set of facts and a lot of gray area. A lot of gray area. We don't get to hear from a detective. We get the state calls the first officer that responded to the scene and was helping with compressions, but didn't search the vehicle himself. And we get to hear from the crime scene tech who searched the vehicle, but decided not to think anything of a knife that was sitting between the seat and the door. So that was something that I thought was interesting. We never really get to hear where Tatiana was, but it seems like we can conclude that Tatiana is still in an intimate relationship with the defendant, Lawrence Dority. So apparently they're now engaged. All we know is that according to Tara Walker, the girlfriend of the deceased, that Tatiana tells her, pull up in 15 minutes. I already called the police. The police bit is stricken from the record. We don't hear anything else about that. And somehow Andre hears that Tara Walker is going to go pull up. Lawrence Dority doesn't know Andre that well, saw him show up. Maybe he was brought as a guest to a Thanksgiving dinner one time, but they didn't know each other like that. And Lawrence Dority's not even home. He's not even home. Andre gets there before, or Adreian. I keep calling him Andre. Adreian gets there before him. Tara Walker drives separately. Before Tara gets there, Lawrence Dority, who's in the car with one of his 3 children and his father, Larry Sr., we're going to call him Larry Sr., pull up after Adreian gets there. And then Tara pulls up. Like, and then somehow Tara hears Lawrence's dad saying he should get the gun, and Tara and Larry Sr. seem to be on good terms. Like, there's a lot. There is a lot of just like, how, what? So, oh my goodness. So let me know if you guys woke up with any questions. Oh, and I could catch up a little. Oh, this is yesterday's stream. So let's see. Sorry, guys. I guess they're starting. It was on yesterday's stream. We're like 2 minutes behind, 3 minutes behind. There we go. And no closed captions on this one. I thought we would have them.
The trial here, the trial in front of Adams, or a case that's already played. All right, so we're done with the docket for the morning.
And if you missed yesterday, this court is like smooth moving. During the lunch break for the jurors, this judge had other arraignments come in and get through his docket. Just keep him busy. Hey, FFS. Hey, it's Trenton. Trenton says, I saw plenty of subjective fear, but not objective reasonableness. He would have to believe his kid was in danger or for a reason, otherwise he's guilty. And what I think is interesting is they don't play, there's a 911 call where he's stating that he saw a gun and that he was pulling at his pants. It would be consistent with what he was trying to testify to, but might not have been hit home. But they don't play this 911 call. So, and the state doesn't play it. So I guess he can't play it himself. But thought it was a little weird that the state didn't play it. And thought maybe the defense attorney, even though maybe it would be self-serving hearsay, I feel like after he was impeached by the state, there are things that the defense attorney could have done. Like the defense attorney could have brought in more statements from the detective interview, and we didn't get that during redirect. And I thought that was the opportunity there to establish and underscore what could have been objective reasonableness. And we just didn't get it. Oh, factual. Yeah, I can't watch funeral processions. Like, I'm a baby. Oh, good morning to Mary. Hey, Tay-Biz. Yeah, Nem says it's difficult. I think the prosecutors didn't really show us that it was not self-defense. They're hiding the details, and details are important here. I'm not sure if I can say it's not self-defense. I think this would be an interesting jury deliberation room. Like, just to be the, I mean, I guess it'd always be interesting, but.
I'm on behalf of Mr. Dority.
Right on it. Mr. Dority is also present. All of our jurors are back. I have handed out copies of the jury instructions to all parties. There's copies for the jurors, and I do have the verdict forms up here that we all discussed yesterday. Any other matters or issues that I need to discuss or take care of from the state?
No, Judge, just for as far as jury instructions, do you read the majority of the instructions before closing or after? Judges split them differently.
I don't have a preference.
I typically prefer the majority of them to be read before, but again, that's obviously.
I don't have a typical practice. If you want me to do it, I'll do it. If you don't want me to do it, I won't do it. If you want me to do it, tell me where you want to be to stop at.
I have no preference either way. I have no preference either way.
I'd want them before if I was the defense, I think.
I would suggest potentially going up until rules for deliberation, stopping there, and then closing arguments, and then going the rest of the way from rules for deliberation. It's on page 12 of your instructions. Or 13.
Okay, so you read up through the rules for deliberation, stop there, have you do your closings, and then read those remaining 3 or 4 instructions and send them out.
That would be the state's preference. If everybody else is in agreement.
Any objections?
No objection, Your Honor.
Okay, I'll do that. Anything else from the state you need to address?
Nothing further from the state.
Anything from the defense?
Nothing.
All right, we discussed yesterday, each side agreed to do their closings in 45 minutes or less per side?
Yes, Your Honor.
Yes, Your Honor.
All right, we do have all the jurors back, so let's go ahead and bring them in. All right, have a seat. All right, ladies and gentlemen, welcome back. I trust that you all complied with the instructions. You didn't do any investigation or any research on your own or have anybody have any contact with you reference this case over the evening, correct? All right. When we spoke yesterday, both the state and the defense had rested their cases. The court released you all early so that we could finish the jury instructions and the verdict forms. We have completed that. You do have a copy of them. You're free to take those back into the jury room with you. What we're going to do is I'm going to split up the way that I read the jury instructions a little bit. I'm going to read the majority of the jury instructions through about the top of page 13 to you now. I am required to read the jury instructions to you. I give you a copy so that you can take them into the jury room with you, but I have to read them out loud to you. The reason I'm reading the first about 12 pages to you is so that you hear from me what the law is that applies to the case before the lawyers argue to you what the law is and what the facts are that may apply to that law. So you'll have heard it from me first, so you know what the law is as they make their arguments. Then they will do their closing arguments, and then I will pick up on page 13 with the last few instructions before I send you out and go over the verdict form with you to let you deliberate, okay? All right, so with that said, we'll go ahead and start with the reading a portion of the jury instructions before they do their closings. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Lawrence Alexander Dority, the defendant in this case, has been accused of the crime of second-degree murder with a firearm. In this case, Lawrence Alexander Dority is accused of second-degree murder with a firearm. Murder in the second degree includes the lesser crime of manslaughter, which is also unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Adreian Payne was killed by Lawrence Alexander Dority, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and adequate provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Lawrence Alexander Dority may be found guilty of second-degree murder or any lesser included crime. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt.
Hey, Angelica.
1, Adreian Payne is dead. 2, the death was caused by the criminal act of Lawrence Alexander Dority. 3, there was an unlawful killing of Adreian Payne by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another person and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Lawrence Alexander Dority did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Lawrence Alexander Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Adreian D'Angelo Payne. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of second-degree murder with a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused the death of Adreian D'Angelo Payne, you should find the defendant guilty of second-degree murder with discharge of a firearm causing death. A firearm is legally defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. To prove the crime of manslaughter, a lesser included offense of count 1, the state must prove the following two elements beyond a reasonable doubt. 1, Adreian D'Angelo Payne is dead. 2, Lawrence Alexander Dority intentionally committed an act or acts that caused the death of Adreian D'Angelo Payne. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Lawrence Alexander Dority committed manslaughter and you also find beyond a reasonable doubt during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm, again, is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. It is a defense to the crimes of second-degree murder and manslaughter if the actions of Lawrence Alexander Dority constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Lawrence Alexander Dority does not have the burden of proving that he was justified in using or threatening to use deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force is as follows. Lawrence Alexander Dority was justified in using or threatening to use deadly force if he reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to himself, or the imminent commission of a forcible felony aggravated assault against himself. The definition of aggravated assault is as follows. An aggravated assault is an assault with a deadly weapon without intent to kill. An assault is an intentional, unlawful threat by word or act to do violence to the person of another, coupled with an apparent ability to do so, and doing some act which creates a well-founded fear in such other person that such violence is imminent. Lawrence Alexander Dority had no duty to retreat before using or threatening to use deadly force. In deciding whether Lawrence Alexander Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. However, the use or threatened use of deadly force is not justified if you find that Lawrence Alexander Dority used force or threat of force to initially provoke the use or threat of use of force against himself, unless 1, the force or threat of force asserted towards the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using or threatening to use deadly force on the victim, or 2, in good faith, Lawrence Alexander Dority withdrew from physical contact with Adreian Payne and clearly indicated to Adreian Payne that he wanted to withdraw and stop the use or threatened use of deadly force, but Adreian Payne continued or resumed the use or threatened use of force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Lawrence Alexander Dority and Adreian Payne. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? And 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law
Someone tell Fulton County that it doesn't matter the sheer quantity of witnesses you call.
enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, I'm going to stop reading the jury instructions at that point. I will pick up with the remainder of the jury instructions after the attorney's closings. As I indicated, both the state and the defense have now rested. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence, nor your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Does the state wish to give their closing at this time?
Yes, Your Honor.
You may.
Thank you, Your Honor. May I please report? Carol Walker pled with the defendant not to take his gun out. She pled with him, don't take your gun out. Over again, don't take your gun out, Lawrence. We were asked to come here. She pleaded with him not to shoot Adreian Payne that night. But he didn't listen. Instead, he proceeded to take his gun out, take deadly aim, and shoot and kill Adreian Payne. It wasn't justified. It wasn't in response to a reasonable threat. It was just because he was intoxicated and he was mad. Not in the heat of passion that would be justified by law, but just because that's how he felt like, what he felt like doing that night. Not justified. Now, this was a relatively short trial. You heard from 6 state witnesses, as well as the defendant, including Tara Walker. And obviously you heard from the witnesses yesterday, so you probably have fresh memories of what was said, but I want to go through and touch on what I think are important points for you to remember when you go back for your deliberations. First, you heard from Corporal Garrett Morris. He was one of the first responding officers on scene. Now he came to the scene and he found the victim suffering from a gunshot, and he was still in his vehicle. Now you heard from the testimony, he was a large individual. He was 6'8", and they had difficulty getting him out of the vehicle. They were able to ultimately get him out. He tried to render aid on the ground and CPR with another officer. Unfortunately, he was unsuccessful. Now you heard, as part of protocol for when responding to a scene like this, a shooting, that he checked for weapons on the victim's person. And you can actually see on his body camera video that you saw that he did check both a pouch that the victim had on and as well as his pockets. No weapons. You also heard from CSI Hannah Miner, who testified yesterday morning as well. She was the lead CSI in the case, and she was in charge of documenting the entire scene, including the inside of the victim's vehicle. And you saw her documentation of that scene produced no firearm. There was no firearm in the vehicle. There was a kitchen knife in the passenger floorboard that you heard from Tara Walker was put there by her after a dinner that they had picked up. You also got to see from CSI Miner's photographs sort of a layout of the scene. you got to see that the victim's vehicle wasn't parked right in front of the defendant's house, but down the street a ways, at least a couple of residents down. You saw that the vehicle wasn't on his property. It wasn't on anything adjoining his property. You got to see the distances between the defendant's door and where the victim had parked. You got to see her photographs detailing her search of the defendant's residence where the firearm was found. And you saw the firearm itself, which is in evidence. You heard briefly from Marco Quintanar, who was a neighbor in this incident. He didn't see anything, but he heard gunshots, which caused him to look at his surveillance camera, and he was able to find video that captured audio of this shooting. And of course, you heard from Tara Walker, the victim in this case's girlfriend, the mother of his child. She told you that she responded to the area of the defendant's house after receiving a call from her best friend, Tatiana Mesa, that she then spoke with her boyfriend, Adreian, who said he was also en route there as backup to her. Now, you heard that she got there sort of just after Adreian had arrived and saw the defendant sort of walking away after apparently having words with Adreian going back into the house. You heard she had a brief conversation with him. He was going to move his car so she could fit to park on the street there. And then you heard that's when things took a turn. The defendant came back outside the house. He didn't stay in the house. He didn't lock the door. He didn't call 911. None of that. Instead, he arms himself with a firearm, taking the time to do that. He comes back out, and when Tara Walker sees him, she notices that he seems to have a gun. And she says, and you can hear on the audio, "Don't take your gun out. Lawrence, don't take your gun out. We were called here." But then she told you he didn't listen. He does take the gun out. You can hear the escalation in her voice. While you can't see the incident, you can hear it play by play from her voice on the video and the shots themselves. And you hear just after that, after he's been warned, after he's been told while they're there, you hear the shot ring out. And then you hear screams. Because the defendant had killed Adreian Payne for no justifiable reason. And you hear that in that surveillance. You then saw on the video, and you heard from her, that she ran down to a neighbor's house. She tried to get help, and then she continued running, trying to get help from other neighbors. And then ultimately, when law enforcement came back, she was back to the car to try to render aid to her boyfriend, who unfortunately succumbed to the injuries. Now, you also heard from the medical examiner in this case, Dr. Marie Hansen. She told you about her extensive experience as a medical examiner since 1990. She told you about the autopsy she performed in this case. And she told you about the positioning of the victim's body when he was shot, that his arm would have had to have been up like this and to go through his torso for the shot. She said that was consistent with, and obviously she wasn't there, so she can't say specifically, but it was consistent with someone having their arm either perched on a door frame or on a steering wheel, just as Tara Walker said. She also said that based on the position, it's likely that the thumb was down. That's not a position that someone would be pointing a firearm, which we know that the victim in this case never had. But instead, a position of somebody that's by his car or in his car, nowhere near this defendant's residence, not on his property when he was shot. You heard from the medical examiner that the cause of death was that gunshot as it went through and pierced the aorta. And you heard that the manner of death was homicide. You also heard from firearms expert with FDLE, Kristen Killinger, just that confirmed that the gun that was found in this defendant's home was in fact the gun he used to kill the victim in this case. And that the bullet that was removed from the victim in his autopsy was in fact fired from that defendant's gun. Now, you also heard from the defendant in this case, and part of your job, as is your job with all the witnesses that testified, is to weigh their credibility. Now, the judge just instructed you with an instruction on weighing the evidence And it goes through the factors that you look at when weighing the credibility of a witness that testifies. And that's your job as a juror, to go through that with each witness and determine what you find credible and what you find to be not credible. Now, I want to talk about some of those that are of particular importance, I believe, to this defendant's testimony. Did the witness seem to have an accurate memory? Well, you heard his testimony as he said certain things with his counsel, but then when I questioned him about it, I said, well, it had been a long day, I'm not sure, I might not have said it. Did you find that to be credible? Was the witness honest and straightforward in answering questions? Well, he was barely audible when answering questions from his attorney, but he was at least cooperative. But then when I asked him questions, you saw his response, talking around the question, not giving me direct answers, having to be impeached multiple times with his previous statements. Did the witness have some interest in how the case would be decided? Well, no one that you heard from yesterday has more of an interest in how this case is decided than the defendant, obviously. Did you find his demeanor on the stand to be credible? Or did you see the tears, if there were any, to be crocodile tears that he was trying to force to gain sympathy from you? What do you believe? Did his testimony agree with the other evidence in the case? Well, no, it was in conflict with the testimony of Tara Walker. And that testimony of Tara Walker is corroborated by the video and the audio from the surveillance video. And did the witness at some point make statements inconsistent? Well, several times. I mean, just out of the door in his direct testimony, he said he had never been Mirandized. But then obviously he was impeached on the transcript of him being read Miranda. He said that he, didn't initially, so they didn't try to talk to the victim when he came back out. He didn't communicate with him. He shot him. That's what he said just after this murder. But then after watching all the evidence, he gets on the stand and says he came out there and was trying to, talk, please leave, please leave. First of all, I question that is the demeanor that he came out and was asking Mr. Payne to leave. But also, Adreian Payne was not on his property. He was on a street that was not even touching his property, and he didn't have any less of a right to be there than the defendant. He also said definitively, as you heard in his direct testimony, he definitely saw a gun, but he never said that in his initial statement. What he said is he thought he saw the outline of a gun. He's not sure, to be honest, he's not sure. That's what he originally said. But after hearing the evidence and realizing what needs to be said in order to convince you that he was somehow justified in his actions, that's what he said on the stand. But it's not consistent with what he said before, and it's not consistent with the facts and evidence in this case. Now, from the evidence in this case, it is clear that this defendant is guilty of second-degree murder with a firearm. The judge just went over with you the elements of that offense as well as the lesser-included offense of manslaughter. But I want to take a minute and go through those with you as well and go through the facts as the state believes they apply. So the judge will instruct you and you have in your packet that you are to convict of the highest crime proven beyond a reasonable doubt. And that's second-degree murder. Now, here there's a lesser-included offense of manslaughter, but I want to be clear, and I'm going to talk about manslaughter, but I want to be clear. In jury selection and in these instructions, you're going to be told to not let sympathy or concerns about sentencing impact your deliberations in this case. So if you believe that we've proven this case beyond a reasonable doubt regarding second-degree murder, it is not appropriate to say, well, maybe he was scared, even if it wasn't justified, or maybe whatever the situation is, he's, not that old. I don't want him to, go to prison for a long time, or whatever the case may be. That is not appropriate. That is not the consideration for the jury. You are to convict of the highest offense proven beyond a reasonable doubt, and that's second-degree murder. But I'm going to talk about manslaughter because we have proven the elements of manslaughter as well, as it is a lesser-included offense. So to prove the crime of manslaughter, the state must prove it's just 2 elements. And there's a couple of big differences between manslaughter and second-degree murder. First, there's just 2 elements. There's 3 elements to second-degree murder. Manslaughter does not require any type of mental state. So second-degree murder requires that he acted with what the law calls a depraved mind. I'm going to talk to you a little bit more about that in a minute. But manslaughter does not require that. It just requires that A, Adreian Payne is dead, which is stipulated to. Obviously, we've established that he is deceased, and that the second element is Lawrence Dority intentionally committed an act or acts that caused the death of Adreian Payne. Now, obviously, in this case, that act is taking his gun and intentionally shooting him. That's it for manslaughter. Now, you're going to see that for second-degree murder, there is an instruction regarding heat of passion. That doesn't apply to manslaughter. So the 2 things that you can consider for manslaughter for elements are that Adreian Payne is dead and that the defendant committed an intentional act that caused the death of Adreian Payne. We've proven manslaughter. We've met those elements, but you should not convict him of manslaughter because that's not the highest crime proven. So I want to talk about second-degree murder. I'm going to put it up here. I know you have it in your packets, but I want to talk about it in a little bit more detail. And if you can't,
I think that was a bit confusing, guys. Manslaughter is a lesser included of murder too. It's a different type of homicide with different elements. And they keep mentioning heat of passion. So if there's provocation, if there's impulse, you know, if it weren't for this passionate moment, this wouldn't have happened. That's a way that somebody, instead of it being murder, the jury could find manslaughter was actually what took place. It's not that helpful, guys. Florida, and FFS is from Florida as well. We're hearing from this attorney, you know, you shouldn't use sympathy, you shouldn't make considerations about sentencing. While the jury might not know specifics of the sentencing, I think most Floridians have heard of 10, 20 life, which is, I know a lot of people think Florida loves guns. Everybody has guns. You can do anything in Florida, crazy Florida man. But I look at Florida as a with great power comes great responsibility state where, sure, you can own a gun. You can carry a gun. I think recently you don't even need a concealed carry permit anymore. Very friendly to owning firearms here in Florida. But if you commit a crime and a firearm is involved, your minimum sentencing timetables are way up there compared to a lot of other states. So if the jurors have a general idea of this, even if they don't know the specifics for a specific charge, I don't think it's unreasonable to think that at least somebody on the jury knows how severe sentencing for a firearm-related offense would be. So just generally speaking, if you're not familiar with Florida, good old Florida.
read it exactly on the screen.
Guns versus gators.
It is on page 3 of your packets. But so there's the same, the first element is the same, that Adreian Payne is dead, and that the death was caused by the criminal act of Lawrence Dority. That criminal act is taking his firearm and shooting him while he's sitting in or by his car.
What's on the screen?
The third element is the difference, that there was an unlawful killing of Adreian.
This looks like the tiniest, and I freak out when I pull paper up on screen and I have to like expand it to try to make it readable. This looks like single lines here. Not helpful.
Adreian Payne by an act eminently dangerous to another, demonstrating a depraved mind without regard for human life. So, ladies and gentlemen, I pose to you that obviously taking a firearm and shooting another human being demonstrates a depraved mind, and eminently dangerous to another and depraved mind is defined for you. It says a person of ordinary judgment would reasonably certain to kill or do serious bodily injury. A normal person knows if you take a gun, you point it out, and you pull the trigger, it's going to cause bodily injury, or it's going to kill him. It's done from ill will, hatred, spite, or evil intent. And I want to point out that these are ors. So you can find that it was done from ill will. He was upset that he was outside his house. Hatred, maybe he was that mad that he was outside his house. Spite or evil intent. You can find any of those. You don't have to find all of them, but if any of those satisfy the depraved mind requirement. And he certainly had that, and his actions demonstrate that he had that. And then finally, is of such a nature that the act itself indicates an indifference to human life. And again, some of these things overlap with each other. Obviously, again, taking a firearm, pointing it, and shooting at another human being shows that you're indifferent to that person's life. Now, with second-degree murder, we do not have to prove an intent to cause death. So that's not something you consider. Maybe he just wanted to injure him or whatever the case may be, if that's what you believe. I think the facts show that he took deadly aim and intended exactly what happened, but you don't have to find that. You don't have to find an intent to cause death, just that he had an intent to shoot him. So then there's the portion that talks about the heat of passion. And there are some subsections here, A through E. But each of them talks about an ordinary, reasonable person. So it's not just, well, I was scared, so I did it. That's not sufficient for heat of passion under the law. It's not sufficient to say, I was upset, and so I did this thing, and I'm excused from it being second-degree murder. No. There must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. Again, that language, ordinary, reasonable person. And again, I want to point out too, all of these are ands. So you have to find all of them for these actions to be reasonable. A reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. So the question is not just, was this defendant in a blind, unreasoning fury? He was certainly not acting reasonably, but would a reasonable person have acted that way? No. There was not a reasonable amount of time for a reasonable person to cool off. This defendant took time. He went in his house. There was no threat at that point. He wasn't pursued. He armed himself. He came back out. There was no further threat. He's being begged and pleaded with to not do what he did, but he still did it. So he certainly could have cooled off when he went in the house. And then another and also has to be met. A reasonable person would not have cooled off. So say he was so upset by whatever interaction that they had out by the victim's vehicle before he went in the house. A reasonable person, when they go in their house, can shut the door, can lock the door, can do whatever, can cool off, before coming out and doing what he did. And then finally, he was so provoked that he did not cool off before he committed the act that caused the death. So it's not just a matter of, I was scared, this was a scary situation, and therefore I did this and I should be excused of second-degree murder. No, you have to look at it based on a reasonable person. And the defendant in this case and his actions were anything but. So the defendant in this case took the stand and claimed that he was acting in self-defense. He was justified in his use of deadly force. But that is not the case when you look at the facts. The defendant's actions were not reasonable. The judge has given you a lengthy definition of justifiable deadly force. That's on page 8 of your packet. And for something to be justified, it must be both an objective justification and subjective. And I want to go through a specific paragraph that is in your instructions that explains that and how that works and what you're to consider. The second from the bottom on this page, I don't know on your packet, but it starts with, in deciding. the judge has instructed you, and you're going to have this in your packet, in deciding whether Lawrence Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force threat was used. So that's important because he didn't use the force, when they first had words and he decided to go in the house. This is after he had gone back in the house, had time to cool off, arm himself, and come back out. And other people, were present at this point, including Tara Walker. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. So first of all, this wasn't threatened use of deadly force. I guess maybe it was in the moments just before he pulled the trigger, but this was deadly force. He did pull the trigger in this circumstance. And he himself must have actually believed in that moment that it was necessary to do what he did. Not that he wanted to, but that it was necessary. And beyond that, even if beyond just necessary in his mind, moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed that the use or threatened use of deadly force was necessary. A reasonably cautious and prudent person. This defendant's actions were not the actions of a reasonably cautious and prudent person. That's for you to decide when you look at the facts of the case and you look at the evidence, but the evidence has shown that what he did was not the actions of a reasonably cautious and prudent person. The defendant in this case was not standing his ground. He was the aggressor. He was the person that initially approached a car parked on the street. This person wasn't knocking, on his door, wasn't standing on his lawn. He was sitting in his car with the window rolled up. He was the one that made even an initial contact. This was not an act of defense, and it certainly wasn't an act of reasonable self-defense. He took a life not to protect his own or to protect his family. He took it because he wanted to, because he was upset. His actions show a depraved mind, and he's guilty of second-degree murder. We ask that you convict.
All right. So, chat, let's rate that on a scale of 1 to 10. If we could split that in half, I'd say above a 5 for the beginning half of it. It was losing me towards the end, too much emphasis. And one of my pet peeves about his closing is I don't like when people apply a standard in one direction only. And I feel like when he was about to talk about the defendant's credibility on the stand, he tried to work in, well, you should weigh the credibility of all the witnesses, but really, I just want you to focus in on how uncredible he is as a witness. And things like that, just psychologically, when I hear it, it steers me to want to, well, how come you only want me to look there? No, I want to weigh the credibility of everybody now. So just personally, the way I react to things, I didn't like that he was like, our witnesses are so credible, but the defendant as his only witness for his own case, look at his credibility, wink, wink. That was a pet peeve of mine. Yeah, Tay Biz gives a 6. We've got some 4s here. We got 4, 4, 4. GV says it was better than his questions. He used a mic the whole time. The only time he did step away from the mic when he was commenting on when the defendant got quiet and audible when he was speaking. When he said that in his closing, this attorney walked away from the mic right then and there. I don't know if that was accidental or for the effect. Heart of Inspiration says 3. I checked out so long ago. Good morning to Heart of Inspiration. So let's see what the defense attorney comes up with. There's things that the defense could work with. But let's see if they do. Yeah, Angelica with the 8.
Maybe Prosmo, briefly.
I would say the beginning I would go higher with around 7, 8. I think it's very critical for the state if they want this murder charge, yeah, they got to define it. They got to be clear. But he got me lost on the legal definitions, and that seemed like a critical. They thought that was a great explanation that they were giving. So, I would die if there's a mistrial motion. Although, oh wait, there was one other thing I wanted to comment on. The there was a part, and I wasn't quite sure if it was just the guy mincing words, but the prosecutor said something to the effect of Tara Walker was away, and then law enforcement came back. She came back to the vehicle. But we had something stricken from the record about 911 being called, the cops being called previously. So I thought maybe he was mincing words, but I was also wondering what he meant by that. It was just weird.
I don't object.
All right, counsel,
And
for defense,
no
you may
objection?
proceed.
All right, here we go. He might just want to display something during his closing and told the judge ahead of time. Oh my God. Oh my God, he's huge.
Good morning, ladies and gentlemen.
I rock with it.
I want to stay at the podium this morning because that I really want you guys to hear what I have to say. Let's forget all the antics, okay? You remember during jury selection, I said we was going to have a real conversation, right? Real conversation. And the state and I felt like you guys were the most suitable jurors after Rodar, okay? There's three sides to every story. I know you probably heard that before. One person's version of what happened, another person's version or perspective of what may have transpired. And then there's the truth, right? The truth, ladies and gentlemen, is you at this point. You determine what the truth, what the facts are in this case. You have the ability to give us justice here today. Okay? My opening statement, I explained to you all what you would hear in this case. And I submit to you that the defense kept its promise. Okay? We kept our promise in this case. This is a case about self-defense. This is a case about reasonable doubt. Now, the state has rested, the defense has rested, and we both are asking you to use your God-given common sense. Consider all the reasonable inferences that comes from the facts that you heard and saw today and throughout the scope of this trial. Consider what you heard, what you didn't hear, what you saw, what you didn't see. Use your common sense, okay? This case is not for the weak at heart. We selected you guys hoping that you wouldn't just have sympathy one way or the other, you know, just unbiased, impartial citizens. This is your highest civic duty to sit on a jury. This is literally the highest mode of citizenship you can have. Sitting right now, being in judgment to decide whether someone should be found guilty for a crime that they've been accused of, and falsely accused of at that. Okay? thought about this last night when I was summing up the evidence in this case, and a huge question just jumped out in my mind. And I already had been thinking about it throughout the scope of representing Mr. Dority, but after the trial, when the state actually presented and showed their hand, you know what that question was? Where's the proof? Where's the proof? The state has a burden, a high burden, that they have to overcome. And I submit to you, the state has not met their burden. They did not. It's not your job to stack inference upon inference upon inference to come to a conclusion that Mr. Dority did not act in self-defense. If you have a question in your mind right now, an unanswered question, if you have an unanswered question in your mind about the facts of this case, if something's not sitting right with you, if something's troubling you, if it's something that you would have wanted to see or needed to see to come to a conclusion and you can't make sense of why you didn't get that, why you didn't hear that, that's reasonable doubt.
Objection, misstatement of the law.
Sustained. I've given you what the instruction is on reasonable doubt. You have it in writing. You should consider that.
He's holding his face.
Understood?
Oh my God.
I'll go directly to the jury. The court has already given to you. And again, you guys use your common sense, okay? And I'll say this a little differently. Mr. Dority is not required to present any evidence or prove anything at all, number one, right? That's not his job. He could have sat at that table, played tic-tac-toe. He could have been texting if the court would allow. Of course, court decorum doesn't allow that, but you get what I'm saying. He didn't have to do anything, okay? Proof beyond a reasonable doubt does not mean proof beyond all doubt. Of course not, right? Reasonable doubt is not merely a possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. If you have an abiding conviction of guilt. On the other hand, this is what I want you to really pay attention to. If after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if you having a conviction is one that's not stable,
What?
one that wavers, vacillates, then the charge is not proved beyond a reasonable doubt. And guess what? You must find him not guilty. Not may, you must do it. So nobody in this courtroom other than Mr. Dority, I don't know if Ms. Walker's in here, at some point, no one, neither of you, the court, myself, the state, was at 2529 Egret Shores Drive on May 9th, 2022. Right? Everything we say is like our best efforts to try to advise you of what happened that morning around 1:30 a.m. It's a very serious case, ladies and gentlemen. And it's a sad fact that, unfortunately, it's a large sum of people who are murdered every year. And we ask you not to just base this case off that type of sympathy that someone lost his life. We acknowledge this is a very sensitive, sad situation. Both families have been impacted. So out of respect for both families, this is a tragedy.
Careful
Mr.
here.
Dority didn't go looking for trouble. When tragedy happens, right, it becomes the duty of law enforcement to be competent, careful, timely, diligent in the performance of those duties, especially when investigating homicides and violent felonies, and doing it without a bias, without a rush to judgment. So let's talk a bit about what the evidence did show, right? The evidence revealed that neither Mr. Lawrence Dority or Lawrence Dority's fiancée, Tatiana Mesa, invited Mr. Payne over. You didn't hear from Tatiana. You didn't hear that from her mouth, that she invited Tara over. Where's the text message? You remember that? Tara Walker wants you to believe she was texted by Miss Tatiana Mesa to come over. Did you see a text message? Where's the proof? The evidence showed that even Miss Tara Walker advised her boyfriend, Mr. Payne, not to go over to Mr. Dority's house. She admitted to that fact. But why? Why was he there? Why was she there? The crime scene was contaminated. And I'm going to expound upon that a little bit later. That's very important. So very important to this case. Fatal to the state's case. It's fatal to the state's case. There was evidence that was not properly secured and processed. Tara Walker's testimony is not credible. There's inconsistency in the state's case. There's lack of evidence in the state's case. And when you go through the jury instructions, that is a factor that tends to go towards reasonable doubt. When there's inconsistency in the evidence, lack of evidence, inability of witnesses to recall what happened, you know. Mr. Dority's actions were justified under the circumstances of this case, ladies and gentlemen. Mr. Dority was standing his ground. Let's talk a little bit more about what you heard over the course of the trial, though. Now, in the opening, the state conceded that Mr. Dority and Mr. Payne had brief words, right? So all of this badgering Mr. Dority on the stand about him allegedly telling a detective that he made no comment, that he just walked out the house and shot this man. Ladies and gentlemen, you heard it on the video that it was verbal. Not only that, Tara Walker, even though she didn't want to really say what happened, she said she pulls into the neighborhood, pulls up to the house, and sees her boyfriend standing outside the car, sees Lawrence Dority talking to him, and based on her words, communication was happening. Such a soft word, right? They was just communicating at 1:30 in the morning. Just communicating. That's not what happened. The state tried to create some sense of a factual inconsistency, knowing the fact of the matter is that the evidence revealed there was in fact a verbal altercation outside of Mr. Lawrence Dority's home at 1:30 in the morning. And Mr. Payne's vehicle was outside of Mr. Dority's house Feel free to ask for a read back of the opening statement if you don't recall that.
Objection.
You can't do
Opening
that.
Statement is not evidence.
Sustained.
No. Oh my
The
God.
state made no mention of Mr. Payne's girlfriend being present during the initial altercation either, because she wasn't. Mr. Payne arrived before her. They didn't meet together. You remember? She was saying that at some point, she decided to text him and say, hey, I'm headed over to Tatiana's house. I don't know, something's going on, something. And he took it upon himself, oh, I'm going to go over there too. I'll meet you there. No, don't go. No, I'm already on my way. I'm on the 408. I'm on my way. Don't even know where he stayed at. Driving around the neighborhood, cabins in the neighborhood, looking for my client's car. 1:30 in the morning. So at some point during the verbal altercation, Tara Walker arrives. Mr. Payne actually walks up to her car. And at some point, she tells him to get back in the car and move his car up some more, closer to the house. But do you remember what Tara said? That when she first arrived, that the first person she talked to was Larry Dority, Mr. Lawrence Dority's father. And what did Mr. Larry Dority say to her? Tara, get back. I'm about to go get my gun. Now, if it wasn't a threat that appeared imminent or of some sense of seriousness, that's consistent. Use your reasonable inferences. You're allowed to use reasonable inferences. So that's one fact that's admitted by the state's own witness. The state has proven the defense's case. When Tara Walker pulled up, Larry Dority told her to get back. I'm about to get my gun. She said, no, don't do that. That's my son's father. That's my boyfriend. Oh, I've never seen him before. That's a big fella. How big is he? Wait a minute, let me see.
Chat. Oh my God.
Medical expert Dr. Hansen said he was 80 inches.
All right, so we can't. Oh. Oh my God. It's very helpful that this attorney is, I guess, short.
Mr. Dority, could you stand up for a second? With your permission, Your Honor, may I ask my client to stand up?
We're
Awesome.
This is like, are you tall enough to ride this ride?
See what Mr. Payne was doing, he was coming to try to pick a fight. He was trying to be intimidating. He was trying
Think
to,
obscure destinations outdoors?
he wasn't coming to sing a Christmas carol outside his house at 1:30 in the morning. He wasn't delivering for Uber. He wasn't delivering for Amazon. He had no right to come to his house. Now, if you believe he has a right to be in the street, just parked outside, just waiting, lying in wait for someone with your car running, headlights on, just sitting in the car, and then when someone walks up thinking that you're someone you know, you hop out with a threatening gesture. Mr. Dority goes in the house. A reasonable person, you know what a reasonable person would do after having an argument outside of someone's home that you don't have a right to be at 1:30 in the morning? And when that person gets ready to go in the house, after you threaten the person and he goes in the house, by the time he comes back out, you should be gone. But guess what? He moved up a little bit closer.
Okay, +1
And
for
guess what?
mentioning that.
Mr. Doherty's son was still outside, who was 9 years old at the time, 8 or 9, give or take. His dad was 62 years old. There's inconsistency in the evidence, ladies and gentlemen. There's lack of evidence in this case. So let's talk about Deputy Garrett Morris. He was very forthcoming and candid, professional. He arrived at the scene. You can see it his body camera. He rushed over, and basically he was administering life-saving measures to try to revive or try to just get some sense of keeping Mr. Payne
He was doing
viable to paramedics can arrive. You know, he arrived, he located Mr. Payne in the driver's seat at that time, one left foot out of the vehicle, right foot in the vehicle, you know, but he wasn't all in the car the whole time now. Only after this shot hit him and set him down, he went and got in the car. Because you remember, I was talking about Dr. Hansen. I don't want to jump around too much, but I'm going in the order of where the state called their witnesses. So just walk with me through this journey of justice real quick. Just walk with me for a second.
If there was an objection there for facts not in evidence, we have his arm kind of like outside the doorway, but not that he's fully
Detective
outside the car,
Garrett
right?
Arrived, pulled Mr. Payne out of the car and started trying to administer CPR. Okay. He did a brief search of Mr. Payne's fanny pack. He did not see any weapons in there, but he did not search the vehicle at all. Okay. That's pretty much all he did. After this, fire and rescue arrived, and then Deputy Garrett says he maintained the crime scene. Just himself, just Deputy Garrett maintained the crime scene. He testified that he put up crime scene tape. And he held the area around the car until homicide and forensics units arrived. Now, he was equipped with body camera footage, remember? Did you see if he maintained the area on that body camera footage that you saw? Where's the proof? Body camera's on. You on duty. You're working. See, the state is trying to cherry pick with you. They're picking to try to show you some things, to try to spoon feed you. You ever had Thanksgiving dinner that was so nasty that you had to sprinkle a little sugar on it to make it taste good? That's what this tastes like. That's what this is. No, don't let them force feed you. If it's nasty, it's nasty. All right, let's proceed. The state published the body-worn camera footage, and the footage did not reveal that he maintained his area around the car. In fact, there is no evidence that the area around the car was even secured or maintained free of contamination or free of manipulation. Also, Deputy Garrett candidly admitted that when he arrived on the scene, the passenger side door of that black Chevy sedan, that Malibu, was already open. Now, he initially testified that he believed Tara Walker was on the passenger side, but then he couldn't really say that because the door is already open by the time he arrived. All right? And again, he did not search the interior of the vehicle. And I ask you again, where's the proof, right? Somebody gained access to the passenger compartment of the vehicle.
This is important.
That door was completely open.
He needs to hammer into
Tara
the rummaging.
did say at some point in her testimony that she went on the driver's side. I'll get to her testimony in a second. I'm just going to keep going down chronologically. But you know what else jumped out? And I hope you guys asked to watch that video again. If you listen closely to Deputy Garrett's body camera footage, Tara Walker is heard in the background saying, "Why am I here? Why am I here?" You said you was here because you was invited.
That's a good point.
Seemed more like a setup or something. What's going on? You know, Tara has a motive to not be honest in this situation, because you know what this is? When Mr. Dority arrived home and he approaches the vehicle that he was familiar with at one point, believing it to be Tara Walker, but unknown to him, a 6'8", 247-pound man steps out and in a threatening manner steps over to him and say, I'll smoke you. What you want to do? That's an aggravated assault with a weapon. That's a felony, a forcible felony. And if Tara Walker invited him over to do that, that means she conspired with Adreian Payne to commit a forcible felony of aggravated assault. Use reasonable inferences, ladies and gentlemen. So let's talk about Hannah Minor, the crime scene investigator. She, at the time of this incident, May 9th, 2022, she had only been employed as a crime scene investigator for 4 months. She had just started January 2022. So she's 4 months in on the job, relatively inexperienced. And it technically shows, because the role of a crime scene investigator is to respond to the crime scenes, document the crime scenes with photos, notes, sometimes measurements, document evidence, collect evidence, process that evidence, package that evidence, forward that evidence to its final location, whether it's in a laboratory or evidence unit, and write reports of their involvement in those cases. And of course, they work in conjunction with law enforcement and detectives. This is her exact testimony, right? It's from my notes, right? But she failed to document and process, collect that knife. She didn't dust for prints. She testified that it can be done, and case by case it can be done. She didn't try to get any touch DNA. She testified that she can do that. It's case by case. So in a case like this, a homicide allegation, if someone died, that's not something where you think that's important to dust. She agreed that it can be a weapon. It is a weapon. But Tara is saying she's just been driving around with a kitchen knife for 4 months. A mother is not driving around with a kitchen knife on the front passenger side floorboard in plain view for 4 months. That's not believable. Well, one would hope or think. So May 9th, she was on call, crime scene investigator. Their office is short-staffed. They're only staffed to midnight. So any calls that come in after midnight goes to the on-call crime scene investigator, where they take the call from home. Miss Minor, investigator Minor, she didn't get notified till 4 a.m. This incident, Mr. Dority arrived at 1:30 in the morning, right? Do you remember the testimony of Tara Walker when she said her brother arrived at 2 a.m.? Follow this for a second. 1:30 in the morning, he gets home. 2 in the morning, Tara Walker's brother arrives. 3 in the morning, Tara Walker's father arrives. 4 in the morning, crime scene investigator is notified, and 5 in the morning, she arrives. 7 in the morning, Tara leaves with her car still at the scene. Crime scene investigator never took a picture of her car, never searched her car, didn't even know her car existed, although Tara was alleged to have been at the scene at the time of this incident. Nobody even took identification from her brother. What is her brother's name? Nobody knows. What kind of car he drive? Tara said a BMW. Crime scene contamination. You heard testimony from Mr. Dority that he's seen her go in the car and run, and she didn't come back out until she was talking to law enforcement, till law enforcement arrived. But what time did law enforcement arrive? The only person you heard from was Deputy Garrett. Where was the other officers, if any? And what time did they get there? How could you secure a crime scene? Where's the proof? It's akin to someone throwing rocks at a glass window, and when you come outside to confront them, they're hiding their hands. Where's the proof? This is serious. This is someone's life. The state wants you to believe that my client just comes out the house, guns blazing, just shooting at someone for no reason, in cold blood, without adequate provocation, without it being in fear, just willy-nilly. Use your common sense. That's not what happened. And it's not the defense's job to show you things that it's not even, it didn't happen. The video that the state showed you doesn't even show the actual, it doesn't show any body, any person in any frame All you hear, it's a video of audio. It's a video of audio. They didn't. Well, how about this, if this don't convince you? When Mr. Dority testified and the defense rests, the state didn't even put on a rebuttal witness, no rebuttal evidence. They haven't rebutted self-defense.
Not really how that works, but okay.
Their own case established self-defense, arguably. And after hearing from Mr. Dority, who refuted that? Tara wasn't there when he first encountered Mr. Payne. Now, I imagine what may be troubling you guys is that there was actually no gun found in the car, but it's a reasonable explanation for that. You know why there was no gun found? Because the gun that he had was removed, either by Tara, her brother, or somebody.
Objection, facts not in evidence.
That's a reasonable inference.
Overrule.
You are allowed to make reasonable inferences based on the facts. That's her job, to collect and document the knife. It was still in the car, not taking in evidence at all. You didn't even have a chance to see it today. I couldn't present it to you. It was not taken into evidence. That's not fair. The state can strike hard blows, but they can commit fouls now. Mr. Payne's girlfriend, her car was on the scene. It was never searched, no picture taken or anything. Investigator Minor agreed that she did not document the vehicle. She wouldn't know what was inside the vehicle because she didn't document the vehicle. And she agreed that part of her duties were to collect evidence, and she failed to document or collect evidence. This means this was an incomplete investigation, insufficient investigation. Marco Quintana, the neighbor, had that Google Nest camera. He didn't see what happened. The actual altercation didn't occur in video, but you just had the audio. He basically just provided them with audio. Not much value to the case at all, other than just at least allowing you to see that an actual argument did happen. You can hear that something happened outside, and then you hear the gunshot. Mind you, Mr. Dority only fired one shot. It's not like he unloaded a clip. He shot to repel the threat. He didn't shoot to kill. He didn't ask for what happened. Even in the state's opening, he says that Tara Walker speaks with her boyfriend and he decides to come over to the residence as backup. Backup? Backup for what? I hope that you guys, you have to base this case on the facts that you heard in court, not anything external, not just, this is the case. The facts are the facts, and they didn't meet their burden. They didn't. Tara Walker says that Tatiana Mesa texted her and said, meet me at the house in 15 minutes. Did she meet you? Where was it? There was no meeting. It's not right, ladies and gentlemen. You are empowered with the ability to give us justice here today. Justice demands not guilty. His actions were justified. When you go through this jury instruction and look at the justifiable use of deadly force instruction, all those elements are met. It's like, think about this. The elements, you think about elements of any type of crime or any type of rule of law. Think about a peanut butter and jelly sandwich, right? You got peanut butter, jelly, and bread. If you're only presented with bread and peanut butter with no jelly, then guess what? It's not a peanut butter and jelly sandwich. It's missing a necessary element. This is a very simple case. Very simple. Getting back to some of the comments, Mr. Payne, instead of leaving, pulls his car up closer to the home and gets back out of the car. Mr. Dority again questions, why are you here? You need to leave. You can't really hear much of the conversation. Like, it's muffled. It did happen relatively quickly. It happened relatively quickly, And you can see in that video that my client's son was very, very close in the vicinity to this situation. And it was not until Mr. Payne reached in a threatening manner as if he can pull. It just goes back to Dr. Hansen, right? Let's talk about her for a second. She has 35 years of experience, 35 years since 1990. She did maybe 250 to 300 autopsies a year for 35 years. And she testified that the trajectory of the bullet wound that Mr. Payne
He should pull the prop forward.
Pierced the tissue of his bicep. Mr. Femur twisted it, just pierced it, and then it went into his chest cavity. But it's consistent with this movement. Thumb down, arms raised. How is this not consistent with someone trying to aim a firearm at you if you're left-handed? The testimony is he was left-handed. You can absolutely aim a gun. I apologize if I'm aiming at you like this, but I really need you to see this. A gun can be aimed like this. This is consistent. And just because the gun wasn't located, but you have a reasonable explanation for that. I can see if you didn't have that. I can see if the crime scene was not contaminated. I can see when law enforcement arrived, the passenger side door wasn't open, wide open. I could understand it if Miss Tara Walker's brother did not arrive at 2 a.m. before law enforcement did. Or at around the time of, had to be before, because he wasn't documented. Was he invited over? Who invited him? Sounds like an ambush. Seems like an ambush. That's a reasonable inference that can be made. Nonetheless, Mr. Dority reasonably believed that Mr. Payne had a firearm on his person. And there is a strong inference that there was. Either Tara's brother left with the gun, or Tara left with the gun, or the gun was left in her car, or her father took the gun. The crime scene was contaminated before law enforcement arrived there. Tara's testimony should be taken with a grain of salt at best. She didn't even want to acknowledge the fact that Mr. Payne arrived on scene before she did. Vacillating between that. Evasive. You remember when I asked her on cross-examination? Before Mr. Lawrence Dority walked away and went into his home, he actually asked Mr. Payne, why are you here, right? Tara Walker says, I can't recall if he said that. Can't recall. How convenient for you not to be able to recall that fact, but you can remember everything else, like the selective amnesia when a fact is not a fact in your favor. Come on.
Kat called that out yesterday.
Come on.
You guys are always on it.
How's this justice? How's this fair? Where's the integrity of this prosecution? Remember, the state had the burden to overcome. Remember that. There is so much wrong with this. The integrity of this prosecution cannot be established beyond a reasonable doubt. The state tried to impeach Mr. Dority about what he said to police, but they failed to show you the interrogation video.
Objection. Halliburton equally available for defense.
Sustained.
The burden is not on us.
Why are you smiling
You hear
like
that?
that?
The state want us to provide you with evidence when it's their job to do that.
Now, I will say he did make a best evidence objection. And, after the stream yesterday, there was a comment from somebody that said, hey, there's certain things that, because it would be self-serving for the defense to introduce on their own, they can't just willy-nilly introduce something that would be self-serving hearsay. However, my question is, since the prosecution was introducing it as impeachment, and it either wasn't complete, we could have read more parts of the transcript to expound on. We read articles yesterday outside of court where during this detective interview, the defendant does say multiple times that he saw a weapon and that the deceased continued to reach for his belt line as if to brandish something the shape of a gun. Said it several times in this interview with the detective. We did hear a best evidence objection, which we thought maybe he wanted them to just play the video instead of reading from the transcript. But at the same time, once it's already coming in as impeachment, this attorney could have and should have gotten up there on a recross. Now that the evidence is put out there and under rule of completeness, let's read some more statements. Let's put all of this in. And he didn't do that. And I think that was one of the biggest misstep that this attorney made. That, in addition to, possibly calling another witness. I don't know what his reason was for not calling maybe the dad or Tatiana. I think for Tatiana, he thinks it's good enough that he can motion over to the gallery and point out that Tatiana is in the gallery and then get testimony from Lawrence. Hey, we're actually engaged now. So let the jury make an inference that Tatiana and the defendant are still together, that they haven't separated over this issue. Right? But I don't know. I think he made a huge mistake by not coming back at the prosecutor's questions yesterday.
You got to hold that against them. Throwing rocks at a glass window, hide your hands.
Judge, can we approach?
Yep.
Oh my gosh. Shout out to Obscure Destinations Outdoors for becoming a member. You look good in green. Oh my gosh. It's probably well, damn. And don't forget, guys, seriously, this cutout figure is just standing behind the attorney the whole time he's doing this closing. We just can't see it. And it could all be so simple. Point out the time difference between the incident and the crime scene tech showing up, that we have testimony that Tara Walker rummaged through the car, that the defendant saw a firearm, that the victim was trying to show a firearm. It was great that he pointed out the medical examiner saying that the hand would have been at this angle and not like this. Put all those things together. And that was a very good, reasonable inference that he pointed out, that you could infer that he was pointing a firearm at the defendant. It could be that simple and clean.
Remember, it's their burden, ladies and gentlemen. Literally, this is a homicide investigation. What kind of investigation was this? This case is literally about who do you believe at this point. It's literally Lawrence Dority versus Tara Walker. No other witness brought any value to this case, ladies and gentlemen. Crime scene investigator didn't collect evidence. She admitted that to you. Maybe due to relatively inexperienced tenure of being a crime scene investigator, but it's not to talk bad about her. She's very educated, obviously. But the state has utterly failed to prove that Mr. Dority did not act in self-defense. This appears to be some sort of rush to judgment here. Some sense, it's what this was. Ladies and gentlemen, Mr. Dority has exercised his constitutional right to a jury trial. And we truly believe you will make the right decision here today. Justice requires a finding of not guilty. He acted in self-defense of himself, his son, his father, given the darkness of the night, 1:30 in the morning, the size difference. He cooperated with law enforcement. Why was Mr. Payne there? Why was Tara Walker even there? This was a setup. Why didn't they leave?
Why did he pull forward? Say it.
Mr. Dority was not intoxicated. There's no evidence of this. Mr. Dority's father drove him home because Mr. Dority's vehicle was in his own driveway. How else would he get home? Walk with his minor son at 1:30 in the morning? We're not challenging whether the firearm was functional or not. So FDLE testimony from Ms. Kristen Killinger, not an issue. Mr. Dority testified at 1:30 in the morning. He, his father, and his son was on the way home. As they arrived home, Lawrence sees a car parked in the corner of his home, and he automatically assumed it was Tara. So he thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. So Lawrence walks over and to greet her, to say, hey, or inquire, why are you parked here? Mr. Payne gets out the car, and when he gets out, he's looking down at Lawrence. He has his hand in his waistband. Lawrence could see something silver sticking out on the side of his hip with his hand on it. And Lawrence asks him, what are you doing here? Mr. Payne replies, this is the words from my notes. He actually said, I'm not playing with you, I'll smoke you. That's what he said. I'm not playing with you, I'll smoke you. Lawrence replied by saying, what? Threw his hands up in the air, started freaking out. Lawrence's dad rolls down the window and asks, is everything okay? Lawrence replied, I don't know. He goes into the home, retrieves his firearm so he could safely get his son in the house. So he returns outside and sees Mr. Payne has moved his car up even closer, and he's gotten back out of the car again. At this point, what do? It's dark. You have no duty to retreat, first of all. If it's troubling you that he didn't remain in the house and go hide in the closet and get on his cell phone and call the police, he's not required to do that. He's protecting his castle. He's protecting his son. He's worried about his father. Why are you here? Can you please leave? Mr. Dority is 5'8", 145 pounds, had no relationship or affiliation with Payne. Lawrence did not invite Payne over. Out of all the 15 years he known Tara, he had only met that man maybe twice. One time at some girlfriend's mother Thanksgiving or something like that, he showed up unannounced. And he couldn't even recall the other time he met him. Lawrence went back in his house because he felt like his life was threatened. The jury instructions, the law in the state of Florida supports self-defense in this case. This is one for the books. You have the ability to send a message.
Objection, improper, asking of a jury to send a message.
Sustained.
Ladies and gentlemen, we trust you will render justice and make the best decision, one that is fair, one that justice requires. Lawrence was just trying to go home. Lawrence didn't know what Mr. Payne's mental state or his motives. You know what was going on.
Counsel, your 45 minutes that you imposed on yourself is up. You need to wrap it up. You started at 9:55. It's 10:40.
Thank you, Your Honor. Ladies and gentlemen, we trusted you would do your job today and find Mr. Dority not guilty, because that's what justice requires. There was no rebuttable evidence. Not guilty. Thank you.
State wish to give its rebuttal?
Yes, Your Honor.
Chat. All right, we gotta rate that, guys. We gotta rate that. So if we could condense that down to the little bit of that chronological story at the end that points the story where maybe it was self-defense. He's standing, there's something silver. Remember the motion of the arm. All of that went back in the house. The son was still outside, wanted to protect the son. I don't think we emphasize that part enough because we have to get over this. Why did you go back inside and then come back outside? But there is a reason. If you can make a case for it, there is a somewhat reasonable reason, but you've got to make it appear reasonable to the jury. If we had condensed some of that down and trimmed out everything else about the willy-nillys and the peanut butter and jellies, oh, I think we would have been at like a 6. But because there was all this other stuff going on, I think I'm at like a 2.5. like a generous 2.5. So, yeah. So you guys, yeah. I think FFS just says, oh dear. We've got a 2. That's awful. A 0.5, a 1.5, 2, 4, 5, 2 at most. 2, because most of what he said was on topic, if irrelevant. Yeah, the sugar at Thanksgiving. Nem says lawyering 6, personality 0.5. Yeah, and I think unfortunate, right? Unfortunate that the personality can play a part, but it can play a part. You know, you do not want your defense attorney to be hard to follow, boring, unlikable. People are human. Amber says, well, not the best, better than the prosecutor. The dang peanut butter and jelly. So there we go. Let's get to rebuttal.
The moment to
What the jury's having for lunch. Oh, look at them. Oh, Mr. Big Play Bray. Trial 1 of Karen Reed. They had to tell Lally he was over his time, the prosecutor. We're dipping the light.
I don't need the lights off just yet. I gotta get the shut up.
He let them shut the lights off one by one, paused, and then said, oh, don't do that yet.
Thanks. So one of the first things that opposing counsel said in their closing argument was that you should use your common sense. And the state wholeheartedly agrees with that. Use your common sense. We don't ask anybody to check their common sense at the door. The facts in this case, if you look at it using your common sense, you'll see that this defendant wasn't acting like a reasonably prudent person. Now, opposing counsel stated correctly, the state has a high burden in this case. We have a burden of proving this case beyond a reasonable doubt. And that's our burden in every criminal case. Same as a murder case versus a driver's license case, the same burden. When we were in jury selection, we obviously hadn't met that burden. The question was asked, I believe somebody, if you had to give a verdict right now, what would it be? Obviously, you heard no evidence, you're not guilty. Opening statements aren't evidence. So anything you heard after opening statement, if you had to give a verdict at that point and deliberate, it should be not guilty. But as evidence comes out in this case, that cloak of innocence is stripped away and has been stripped away from this defendant in this case. And with the evidence that's here and the evidence that you heard on that stand, he now sits before you a proven guilty man. So, we do have to meet the elements in this case. And opposing counsel talked about a peanut butter and jelly sandwich, right? So have a peanut butter and jelly sandwich, you got to have the bread, you got to have the peanut butter, and you got to have the jelly. Those are the three elements. So, a pretty good analogy to the elements in this case. For manslaughter, there's just, the two elements that we talked about, then the three elements for second-degree murder. And that's what we've got to prove. We've got to prove each of those elements beyond a reasonable doubt. But opposing counsel also said in his argument that if you have any questions or any questions about any of the facts in the case, then that's a reason to find the defendant not guilty. That's not true. That's not correct. We have to prove the elements beyond a reasonable doubt. But if you're going back there and you're wondering, well, I have a question whether the victim's car was gray or black. I don't think the state established that. Well, that's not an element. We don't have to prove that. So if you have a question of whether the car was gray or black or something like that that's not an element, that shouldn't influence your verdict. We have to prove the elements beyond a reasonable doubt, and we've done that here. We've made the peanut butter and jelly sandwich, as opposing counsel talked about, because we've hit those three elements for second-degree murder. Opposing counsel talked about a text message that you did not see the actual text message that Tara Walker, talked about. Okay, I mean, you can believe what you want. Obviously, weigh the credibility of the evidence, but she showed up there. You can use your inference, as opposing counsel said. Why was she there? Right? She said it was because she got a text message. All right, you can decide if that makes sense. Opposing counsel talked a lot about the crime scene being contaminated, but how? You didn't hear anything in the testimony, the evidence of how it was actually contaminated. They infer that somehow maybe with no evidence that the gun was present and was taken. But there was nothing that you heard. Nobody testified to that. None of the evidence you heard showed that. They talked about, Corporal Morris, the first person that arrived on scene. Yeah, he didn't search the vehicle because the first response was to try to save a life because of the actions of this defendant. And his priority at that moment wasn't to secure the vehicle that he was, right next to. And you can see, that he was there the entire time, that the defendant's father was there, that Tara Walker was there. And she was, by the way, hysterical this entire time. From the moment that this defendant shot the victim in this case, and she runs to the neighbor's house to when law enforcement responds, and you can see on Corporal Morris's body cam, she is hysterical. Is this a person that's in that moment just beside herself? She's gonna take a gun or something and try to hide it somewhere? Ladies and gentlemen, in your instruction, it talks about beyond a reasonable doubt, but it also talks about what's not beyond a reasonable doubt. It's not a possible doubt, imaginary of what could have happened with this gun that was never there, speculative, forced doubt. That's what that is. It's imaginary. It's speculative. Now, opposing counsel talked about the height difference between the defendant and the victim. And yes, the victim was tall. He was, 6'8". But this, and you can consider the relative height, but this wasn't a fist fight. This wasn't even something at the time that the shooting happened where they were in arm's reach of each other. It doesn't matter how tall you are when the other person has a gun. And yeah, if the victim and him were engaged in a fist fight, maybe he feels the need to bring a gun out to defend himself at that point. That's not what happened. That's not the facts of this case. So the fact that he's 6'8" doesn't have any bearing on whether his actions were reasonable. They weren't reasonable. Also, opposing counsel talked about, Adreian Payne should have left. Maybe he should have. None of us were there, but there's one person on trial today, and that is this defendant, not Adreian Payne. He's not here today because the defendant acted in the action that he did, and he killed him. That's why. Now, opposing counsel talked about the defendant's son and father being present, but the defendant even acknowledged in his own testimony, begrudgingly, that there were no threats made to his son, there were no threats made to his father. He wasn't protecting them from some sort of threat from the victim in this case. This is a point that I really wanted to address from opposing counsel's argument. He talks about, if you go back and you listen to the body cam from Corporal Morris, you'll hear Terrell Walker say, "Why am I here?" It's not like, why am I here? Like this, and like that's some big conspiracy. I encourage you to listen to that body camera. She is hysterical, and she's standing there and she's asking, "Why am I here as I watch the father of my child be murdered? Why am I here for that? Why am I living through that?" And there's one reason that she was the defendant. Now, there's a lot talked about by opposing counsel about the knife, the kitchen knife that was found in the passenger seat of the vehicle. And why that wasn't collected. Well, this wasn't alleged to be a stabbing case. There was no allegation that anyone was stabbed or that the knife was used. Also, the defendant, in his testimony yesterday, got on the stand and said he saw this silver object. But when I asked him, "Did you say that in your interview with law enforcement?" "Well, I don't know. It'd been a while." This is right after it happened. He didn't say it then, but he said it yesterday. Why? Because he got to hear all the evidence in the case, and he got to craft his testimony in a way to try to make it seem justifiable what he did. But even by his own words, he couldn't quite wrap it around the requirements of the law. Because even by his own words, what he did was not justified. Now, opposing counsel is right that when he first had his words, or whatever the case was with the victim in this case, and he went in his house, he was not required to call 911. That's true. He's not required to do that. He's not required to cower or anything like that. But that doesn't mean that because he's not required to do that, that somehow that makes his actions justified. He has to meet the requirements of the law that we talked about previously, that his actions were something that a reasonably prudent person would do. Just because he didn't have to call 911 doesn't mean his actions of arming himself with a gun, coming out and shooting a person that's not in arm's reach of him, not on his property, not armed, is reasonable. So yeah, he didn't have to call the police, but he was not justified in doing what he did. So, opposing counsel talks about defending the castle, defending his home. Again, I want to emphasize to you that the victim in this case never set foot at his house, never knocked on his door, never stepped in his driveway, didn't park in his driveway, didn't park in front of his house, didn't step on his grass. He wasn't defending his castle. He saw a vehicle that he recognized. He went over there at 1:30 a.m., had the person roll the window down, and that's what started the engagement between the two. He did that. He's not defending his castle. And then he went back in, armed himself, and came back and shot the person in his car on the street. So he's guilty. Now I'm going to play for you the clip that shows the audio and then Terrell Walker running afterwards. And you can hear for yourself. You can't see it, but the audio paints a picture.
We're gonna have the volume a little bit. Maybe I'll lower it even more because it was very loud yesterday.
Don't put your gun out. You're asked to come here. Pleading with you. Do not pull your gun out. Do not pull your gun out. You were asked to come here, Lawrence. Notice what you don't hear there. You don't hear anybody yelling, Adreian, put your gun away. Adreian, don't pull your gun out. Adreian, no. You know why you didn't hear that? Because he was the aggressor. He's the one that pulled his gun out. He was the only person making a threat, and he's the person that's guilty of second-degree murder. The state asks that you find him guilty as charged, and you find all of the firearms enhancements that are on the verdict form that you're going to get. Thank you.
Here we go, chat. We've got a little bit more instructions from the judge. Strong way to close the rebuttal,
Ladies
I
and
would
gentlemen,
say.
we'll resume with the remainder of the jury's instructions beginning on page 13,
I love that the jury has the instructions.
starting with rules for
them.
deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think that I prefer one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and I will go over with them with you at this time. The first one is the actual verdict, and then there are 4 special findings that you'll have to make with respect to the firearm, okay? Each of them has a caption. That's the top portion, and it just indicates that it's the case of the state of Florida versus Lawrence Alexander Dority. It has the charge, the division number, which is assigned to this courtroom, and the case number that's assigned to it, and then it indicates that it is in the 9th Circuit here in Orange County. The verdict form gives you 3 options. The first option is we, the jury, find the defendant guilty of second-degree murder as charged in the information. The second option is we, the jury, find the defendant guilty of the lesser included offense of manslaughter. And the third option is we, the jury, find the defendant not guilty. The bottom portion of all the forms is the same. It says, "So say we all," dated at Orlando, Orange County, Florida, on this blank day of July 2025, and there is a place for the foreperson to sign. When you all have reached your verdict, whoever your foreperson is that you've elected needs to do three things on the verdict form for me. You need to check one of the three options: guilty of second-degree murder, guilty of manslaughter, or not guilty, one of those three. You need to make sure that you fill in the date, and you need to make sure that you sign the verdict form, okay? You'll need to make sure that you do all three of those things, otherwise the verdict form is not complete. If you don't do those things and you come back and I see that the verdict form is not complete, I'm required to send you back in the jury room, and I can't tell you why I'm sending you back in the jury room. So I'm telling you why now, okay? So just make sure we get those three things done. In the event that there is a verdict on either second-degree murder or manslaughter, then you have to do the special findings. If you find him not guilty, then you don't need to make any special findings, okay? The special findings, there are 4 of them. The first special finding says that if you find the defendant guilty of second-degree murder, you then must answer this question. We, the jury, find the defendant did, during the commission of the crime, actually possess a firearm. The second option is we, the jury, find that the defendant did not, during the commission of the crime, actually possess a firearm. So special finding number 1 is only required if there's a manslaughter, or if there's a second-degree murder verdict from you all, okay? And so then on this special finding, you would do the same thing. You would select either he did possess a firearm or he did not possess a firearm. Make sure the foreperson dates it and signs it, okay? The second special finding also applies only to a verdict for second-degree murder. And it says that if you find the defendant guilty of second-degree murder, you must then answer the following question. And there's 2 options. We, the jury, find the defendant did, during the commission of the crime, discharge a firearm. Second option is we, the jury, find the defendant did not, during the commission of the crime, discharge a firearm. As you did with the other verdict forms, the foreperson will select one of those 2 options, date it, and sign it. And then the third special finding also applies only to the second-degree murder verdict, if there is one. And it says that if you find the defendant guilty of second-degree murder, then you must answer the following question. And again, you have 2 options. We, the jury, find the defendant did, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. And the second option is we, the jury, find the defendant did not, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. As you did with the other ones, you would select one of those 2 options, date it, and sign it. And then the last 4th special finding applies to a verdict of second-degree murder or manslaughter. So if you have any verdict on those 2 charges or those 2 counts, that count or the lesser included, then you would have to do this finding. And it says, if you find the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The 2 options are, we, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. Second option is we, the jury, do not find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. As with all the other forms, the foreperson will select one of those 2 options, date it, and then sign it. Once you have properly dated and signed and filled out the options for all of the verdict forms that are required, knock on the door, let us know that you reached a verdict, and we'll bring you in to take it at that time, okay? Now, in just a few minutes, you will be taken to the jury room by the court deputy. The first thing that you all should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your deliberations are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you retire or when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have had cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. The deputies, and it cut off, the deputies will collect them before you go in. They'll give them back to you when you get out. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I'm going to talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of these exhibits will be sent to you with you into the jury room when you begin to deliberate.
So they get the jury instructions as a packet. They have it already with them. They're going to have a packet that explains this stuff with them back in the deliberations room. And they're also getting the majority of exhibits in the deliberations room as well. So just keep in mind, if we don't get jury questions, it might be because in some districts, some judges that don't send this stuff back, we get a question, we have to come out to the courtroom to say, hey, can you explain that term? Can you read that instruction again? Or, hey, can we look at this one exhibit? So here we might not get jury questions because they'll have pretty much everything that they need. So
the exceptions to that are, obviously, we're not sending a firearm back into the jury room. If you would like to see the firearm, write me a note saying that you'd like to do that. We'll bring you back in and we can show you the firearm. Okay. The other exceptions, do you have a device that is approved?
I do.
To go back into the jury room? Have you confirmed it?
I have not been able to.
Assuming the parties are in agreement, then we can send back a computer that doesn't have access to the internet or anything to allow you to do research. It'll simply allow you to play the videos that have been placed into evidence. If that's the case, then I can send those back into the jury room with you. So I just need to know from you all.
Good. The laptop does need to be plugged in to work. It's an older laptop.
Okay. So it doesn't have a battery either, so you got to old school plug it in the wall. Okay. All right. Any objections?
No objection.
All right. So all the other evidence will go back with you so that you can take your time, use the computer that's provided to review the exhibits that require the use of the computer. The only exception is I'm going to leave the firearm in here. If you want to see it, let me know by sending me a note. Okay. All right. In closing, let me remind you that it is important that you are to follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the jury instructions as read by the state?
None from the state, Your Honor.
Defense?
No, you're okay.
All right. We had 2 of you that were selected as alternates. So if those 2 of you would remain seated, the remaining 6 of you can go back and deliberate your verdict at this point.
because they're reading the juror information, I think.
All right, the 2 of you were our alternates. We select alternates in the event somebody gets sick. Everybody else is healthy, so this will conclude your all's jury service. If you 2 will just remain seated there, I'll give you some further instructions. The remaining 6 of you at this time may take your notes in the jury instructions and head back to the jury room to deliberate. And they've already gotten their orders. Okay, thank you. All right.
All right.
Go ahead and hand them these.
Yeah, Florida does 6
All right, then have a
jurors.
seat.
In capital cases, you can get the 12.
All right,
and
gentlemen, you all were selected, as I indicated, as the alternates in the case. Whenever we have a case that's going to go more than a day or 2, we will select alternates because life happens, things happen. Had somebody had an illness, a family emergency or something, and they had to be replaced, one of the two of you would have been asked to step in. Fortunately, it looks like the remaining 6 jurors are all healthy, and so they will be doing the deliberations in the case. I know that jury service is an inconvenience. I know that it is an imposition on your time, but it is a very important part of our system of justice and a very important part of American citizenship. And for giving of your time the last 2 or 3 days, I do wish to sincerely thank you. You will not be called for jury service for at least another year, if that's any solace for you. But with that said, this will conclude your jury service. Do either of the two of you need an excuse for the last 3 days? Okay, if you could generate one, I'll have the clerk generate that. You already got it? Yep, all right, so she's already generated it for you. With that said, with my sincere thanks, you are excused from jury service at this time. Okay.
Alrighty. Yeah, guys, so for capital cases, it'll be 12 jurors in Florida, but remember Florida, for sentencing phase for capital, only 8 of 12 need to say yes to death penalty.
Agreed to all the evidence the deputy's taken back?
State's in agreement.
Okay. All right, go ahead and have a seat. All right, Mr. Dority, you have been present for the entire trial, correct? Yes, sir. All right. And you've had an opportunity to provide your input to your attorney at all the important stages and the various stages of this trial? All right. And I know we've talked about them, but we've talked about the witnesses that were called. We talked about the jurors that were picked. We talked about some of the strategy that you and your attorney have made during the course of this proceeding. Have you been satisfied with your attorney's representation of you? All right. Has he done everything that you wanted him to do? Was there anything that he didn't do that you wanted him to do? All right. So is it fair to say at this point that you're completely satisfied with his services? Okay. Anything further from the state at this point?
Nothing further from the state.
Defense? All right. We will be in recess at this point pending a question or a verdict. If you're going to leave, just ask that you give your cell phone number to the trial clerk so that we have ability to get a hold of you and that you remain within 10 or 15 minutes of the courthouse so that we can get you here, okay? All right, we'll be in recess.
All right, so we have a poll going. We'll close out the poll in a second to get some of the number. Well, actually, I can see it without closing it out. So 25 votes in so far. How would you vote? Would you vote guilty second degree? Would you vote guilty manslaughter? Would you vote not guilty? Right now, it's 28% for guilty second degree murder, 36% guilty manslaughter, and 36% not guilty. So majority there leaning not second degree murder. And again, I do think that our chat, and I'm proud of it, I like to say it, I think that this chat understands reasonable doubt. We don't like for prosecutors to win the case without actually doing their job. Always got to do their job kind of separate from actual innocence or actual guilt. Family, is this girlfriend? Is that fiance? So we got family supporting in the chat, in the courtroom. I think it's very, very important to have people in the courtroom for you. So if you ever have somebody that's going through it and you want to support them, try to show up in person, try to be there. Because again, we didn't have Tatiana take the stand, but I think it's pretty powerful that the jury got to hear that they're still together. They're engaged. So she didn't need to take the stand for that to be entered into the air of the court. I think everyone's kind of pointing it out in the chat. You know, this all could have been avoided if girlfriend of defendant didn't contact girlfriend of victim and say whatever was going on, you guys pull up in 15 minutes. You know, without people being brought into the business, this whole night could have gone differently. Adreian Payne may never have shown up at this address. And regardless of whether you think the defendant is guilty or not guilty, if that call, hey, pull up in 15 minutes, was never made, it just never would have, the scenario never would have been on the table. So I'm with that. One thing I'm thinking about that the prosecutor, I think, should have emphasized more in his closing is the trajectory of the bullet. You know, there was an exit, so it enters like shoulder and through the chest, and then seems like it entered or exited lower. So that would be a downward trajectory. And if the defense is saying, hey, the victim got out of the car and my client saw a shiny object and he thought he was going to get shot. And, you know, we heard from the medical examiner, hand was at like this angle, consistent with holding a gun. Well, I would have gotten up on rebuttal and really driven the point home. But the bullet was a downward trajectory, suggesting that if this man is 6'8", they weren't standing. They weren't both standing, because there's no way that somebody that's 5'8" or however tall the defendant is could fire in a way that would give that downward trajectory if the victim was standing up at the time. And if it makes a difference to you that the victim was in the car, that's a pretty critical piece of information. Yeah, Dority, that's my take. They shouldn't have been there. I'm sorry to say, they shouldn't have. Guys, you never, like, a few seconds can change your life. Middle of the night, late at night. I don't doubt. I think it's credible that I'm gonna smoke you. I think that's reasonable for someone to think that that's scary, that somebody's threatening you. They pull up to your house. You don't expect them to be there, but they're there. They say, I'm going to smoke you. Honestly, whether you think they're showing you trying to brandish something or not, if somebody was pulling up in front of my house, kind of parked off to the side, and I'd only seen you once or twice, but I don't know you like that, I just know you're the dude of my girlfriend's friend, and you say, I'm going to smoke you, to me, that's reasonable for you to think this person's going to do something to put you in harm's way. That's just me. I don't know what else somebody would mean by I'm going to smoke you. You know, we're not about to play Mario Kart. You're not telling me, yep, I get the blue controller. I get Yoshi. I'm going to smoke you. Like, we're not talking about that type of context. Yes, that phrase can be used in many contexts and it can have different implications. But the circumstances in that moment, what do you mean? It's middle of the night. I didn't invite you here and you're just sitting here saying you're going to smoke me and you're in your girl's car? So, I don't know. I think there's going to be good conversation back in the jury deliberations room. You know, well, sure, it could have been threatening, but why didn't you just stay inside? Why didn't you tell your son to come inside? When you went into your house, why didn't you take your child with you? And then maybe someone else in the jury room will go, well, maybe they were too far away at that point. Maybe they were still further back in their own car. Grandfather saying bye to the grandson. They weren't near the door. So it's kind of like they're over here. Confrontations happening over here, doors over here. It's like triangulated at that point. Maybe that's why we don't have the son just go inside and everybody's out of harm's way. Why did the guy pull up further? Right? I think there's a lot of conversation to be had in that deliberations room. I wonder if the judge is handling other cases right now. You guys remember yesterday? They're like, all right, while you have lunch, let's do some arraignments. Let's do some arraignments. Because it looks like he's shaking his head down here. Yeah, they're going to smoke you. I mean, was it agreed upon by another witness or just the defendant? So Tara wasn't there. Nobody else would have been there to say it, to hear it. Because remember, Payne shows up before Tara gets there. So Payne's at the house, then Larry, Lawrence, and the son get home, and then Tara Walker shows up in a different car. Which that all goes to Tatiana made the call to the friend to pull up, right? That's weird. We don't even know if Tatiana was there or not. Like, was Tatiana at the Mother's Day party and something happened there? And she called her friend and said, well, they're about to go back to Lawrence's house. Go pull up over there. Like, the jury doesn't have context on that. We don't have context on that. We only heard that little blurb that was stricken. So, I don't know. Yeah, this judge is not having a backlog. We have unmarried cat and dog lady. Shout out to accepting both. Says guilty vote. And we are currently, actually the poll has gone a little bit more in favor of not guilty. So we are at 29%, 27. We've got 2 more votes just came in. 29% for second degree, 33% for manslaughter, and 38% for not guilty. Let's see. Does law and crime have a poll? All right, so I'm going to vote hung jury. They have 428 votes over here. Law and crime is so different from this vibe. They are 77% for guilty, 16 for not guilty. Although, to be fair, if we were to combine the votes here for guilty on second degree and manslaughter, we'd be at 62% for guilty and then 38% for not guilty. So their question's a bit different in nature. So I don't anticipate this jury will need more than today to deliberate, but I'm sure they're going to wait for their lunch. So what I think we'll do, we'll close out the stream and I'll pop back up on the live as soon as I hear that there's any activity in the courtroom. So DTN, this isn't the case. So at the moment in time, the testimony that we have, yes, in the vicinity, the father was somewhere in the vicinity, but the testimony that we have before Tara shows up is that it's Lawrence, the defendant, that goes to the car to see what's up. There isn't testimony that Larry, the child, and Lawrence go and knock on the car and say, hey, all 3 of us are saying hello to you. Oh, you're not Tara. So we don't have testimony that the father was standing there when the men first start to greet each other. So, but there we go, you guys. Let's end this poll. We're ending it with 47 votes here. 38 not guilty, 36 for manslaughter, and 25 for second degree, guilty on second degree murder. So we'll see what the jury thinks. Hit the bell, you guys, because obviously if there's a verdict back in, it's not like the stream will be scheduled in advance. And who's doing stuff right now? Do you guys want to go over and watch the Kesu trial? Another Florida case. Let's see. If someone's streaming that, I can send you guys over there. We'll go on a trip. And again, you know my general advice, guys. If a situation could get messy, the best thing to do, and obviously this could be like Monday morning quarterbacking or hindsight, I don't know, have the foresight. I think we should all have the foresight that if something can get messy, try not to let the situation even start. Don't even let don't let the peanut butter, the jelly, and the bread come together. Okay, so yeah, I should know that because I've heard it out loud. Is Flesh live right now? Okay, so I'm sure that's actually the case he's probably covering. So let's go over there. And this, guys, if you haven't been following that trial, I love the attorney for the main defendant. There's co-defendants. The main defendant, the attorney, is Tara Kawas. She is one of Courtney Clenny's attorneys. I have my personal opinion that I don't think Courtney Clenny is going to get away with things. I think she's going to be found guilty in some capacity for something based on what I know. But her attorney, Tara Kawas, has made some great arguments, very good lawyering. And here we're seeing her not just making arguments on evidentiary issues, we're seeing her in trial. She did great with the opening statements. So you can go check out some good attorneying there. There's lots of snitching and weird stuff going on with witness testimony, lots of plea deals. So if you guys are into that type of mess, that case definitely has that going on. And another Florida case. It's a Florida case. So I think Jacksonville. So let's do... And let me get Taylor's link. I think we redirected to Taylor the other day. So we'll redirect to Flesh of the Gods, but I'm going to drop Taylor Umbridge's link. They are both covering this trial. So if you have two screens, hop between both of them. Oh, really? They have separate juries for each defendant? That's interesting. That is interesting. Okay, and Melanie Little is covering Aaron Spencer. That is the case where the father kills the guy that already, he's like his daughter. There's already like some type of restraining order. And the guy has the daughter in the back of the car, and Aaron Spencer is the father that shows up. They're wondering where their daughter is. They show up. He ends up unaliving the guy, killing the guy. So that's the Aaron Spencer case. Melanie Little's covering that. And then let's see. All right, so this is set. We'll go over to Flesh of the Gods if you just carry over with the redirect. If you want to go watch Melanie Little or Taylor Umbridge, click the links in the chat. Yeah, two juries is crazy. Imagine if they had separate juries in the YSL trial for every co-defendant and they all had to sit there for 1,000,000 days. Oh my goodness. Well, see you over in the other chats, you guys, and we will be back. And Tay-Biz, no, there was no gun found on Payne, but the crime scene tech, the car wasn't searched until hours later. There was like one responding officer that showed up and was rendering aid. And we have testimony from the defendant that the girlfriend was rummaging through the car after being asked to find like something to help compress the wound. She rummaged through the car and then ran away from the car after looking in the back seat and through the glove box. She then runs off somewhere and they have no idea where she goes. And her brother shows up to the scene. Her father show up to the scene. They're there for a while. She ultimately leaves with her brother. So that's where we got the inference from the defense attorney in closing that, you know, use your common sense, put that together. That's an opportunity for someone to get a gun out of the car that could have been in the car. And that's why we don't find a gun. So, oh, and Dolly's live. So that's in the chat too. Dolly does a courtroom roulette. So a bunch of different judges. You guys know Judge Simpson, as well as some others. And if you want to carry over link, FFS just dropped Flesh of the Gods. So let's get over there, you guys. See you in these streets and back up when we have a verdict or question. Bye, guys.